Namaste and welcome to Daily News Simplified, the what, why, and how of newspaper reading. Today, we would be analyzing the Delhi edition of the Hindu newspaper of 21st April 2018. Now, let us begin. Now, the news on the impeachment of the Chief Justice of India has been covered on page 1, page 9, and several other articles also on page 9. Now, with regards to this news, we will not go into the politics of the impeachment of the Chief Justice of India. So, what we'll do is understand the impeachment procedure of the Chief Justice of India with regards to your civil services examination. Now, Article 124, Clause 4, which provides for the impeachment procedure of a judge of the Supreme Court, and wherein the impeachment procedure of the Chief Justice of India is same as the procedure of the impeachment of a judge of the Supreme Court. Now, it was in this respect that the Judges Inquiry Act of 1968 was enacted to regulate the procedure for the investigation and proof of the misbehavior or incapacity of a judge of the Supreme Court or of a judge of the High Court, and for the presentation of the address by Parliament to the President. Now, under the Judges Inquiry Act of 1968, if a notice is given of a motion for presenting an address to the President for the removal of a judge, this notice, if given in the Lok Sabha, it has to be signed by not less than 100 members. And if it is in the Rajya Sabha, it has to be supported by not less than 50 members. Now, this notice, if introduced in the Lok Sabha, is given to the Speaker of the Lok Sabha, or if introduced in the Rajya Sabha, is given to the Chairman of the Rajya Sabha. After considering such material, can either admit the motion or refuse to admit it. Now, hopefully, up till here, you have understood that the impeachment procedure of the Chief Justice of India is same as the impeachment procedure of a judge of the Supreme Court, which is provided under Article 124, Clause 4 of the Constitution of India. And it is under the Judges Inquiry Act of 1968 that was enacted to regulate procedure for investigation and proof of misbehavior or incapacity of a judge of the Supreme Court or a judge of the High Court. And it is under the Judges Inquiry Act of 1968 that if a notice for a removal of a judge is given in the Lok Sabha, it has to be supported by not less than 100 members, while if it is introduced in the Rajya Sabha, it has to be supported by not less than 50 members. And upon such notice, the Speaker of the Lok Sabha or the Chairman of the Rajya Sabha, after consideration, can either admit the motion or refuse it. Now, if the motion is admitted, the Judges Inquiry Act of 1968 provides that a committee shall be formed which would have 3 members as investigating team and would comprise of a judge of the Supreme Court, Chief Justice of a High Court, and a distinguished jurist. Now, this committee will frame charges, obtain a written statement from the judge in his defense, and give an opportunity to the judge for cross-examining evidence and witness. Now, the committee will submit a report to the chairman of the Rajya Sabha if the notice has been admitted in the Rajya Sabha, or the committee would submit the report to the Speaker of the Lok Sabha if the notice has been admitted in the Lok Sabha. Now, if the committee contains a finding that the judge is not guilty, there shall be no further action. However, if the committee finds the judge guilty, then the impeachment motion will be taken up by the House. Now, hopefully, up till here, you have understood that if a notice for the removal of a judge is admitted either in the Lok Sabha or the Rajya Sabha, then that respective Speaker of the Lok Sabha or the Chairman of the Rajya Sabha in which the notice has been admitted would form a committee, would comprise of a judge of a Supreme Court, a Chief Justice of a High Court, and a distinguished jurist. And this committee would investigate charges and finally submit their report to the chairman of the Rajya Sabha if the notice has been admitted in the Rajya Sabha, or submit its report to the Speaker of the Lok Sabha if the notice has been admitted in the Lok Sabha. And if the committee comes with a finding of not guilty, then no further action would be taken. However, if the committee comes with a finding of guilty, then the impeachment motion against the judge would be taken up. And therefore, the impeachment motion has to be passed by both houses with 2/3 majority of the members present and voting, and a majority of the total membership of the House. And if both the houses pass this motion, it will be presented to the President of India. Now, hopefully, up till here, you've also understood that if a guilty finding has been given by the committee, then the impeachment motion is taken up, and this impeachment motion has to be passed by both houses with 2/3 majority of the total members present and voting. And moreover, it has to be passed by majority of the total membership of that house. And if the impeachment motion is passed by both the houses, it would be presented to the President of India. Now, hopefully, up till here, you've understood the impeachment procedure of the Chief Justice of India, wherein this procedure is same as the impeachment procedure of a judge of a Supreme Court. And so now with this, we move on to the next article. Now we've taken this article from page 5. Now the reason this article is in the news because the National Disaster Management Agency or NDMA has alerted that India's coast will be lashed with high energy swell waves, and the height of these swell waves would be between 2 to 3 meters and have a period of 17 to 22 seconds. Now with regards to this article, what we'll do is understand as to what are swell waves and how they are different from wind waves. Now swell waves are massive ripples that form on the sea through a combination of three factors, which are wind strength, wherein wind strength is how fast the wind blows across the surface of the ocean. The second factor is of wind duration, wherein wind duration is how long it blows without interruption. And the third factor is fetch, which is the distance the wind blows across the surface without disruption. Now, as the wind blows across the sea, across the water's surface, friction occurs between the surface of the water and the wind, and because of which energy is transferred from the wind to water. And this transfer of energy results in a rising crest that forms into a wave. And over time, the sustained wind strength and duration results in a buildup of large amounts of energy, forming deeper waves, which are known as swells. Now, hopefully, up till here, you have understood the swell waves are massive ripples that form on the sea through three factors, which are wind strength, which is how fast the wind blows across the surface of the ocean. The second factor is wind duration, which is how long the wind blows without interruption. And the third factor is fetch, which is the distance the wind blows across the surface without disruption from obstacles. And as the wind blows across the water surface, friction occurs between the wind and the water, and because of which the energy is transferred from the wind to the water. And this continuous transfer of energy results in rising crest, which forms a wave, and over time, due to the sustained wind strength and duration, it continues to build energy and forming deep waves, which are known as swell waves. Now, these swell waves are different from wind waves, wherein wind waves are generated by immediate local winds, while swell waves are generated by distant weather systems, wherein the swell wave which is currently in the news has been generated as far away as Madagascar. Now hopefully you have also understood the difference between swell waves and wind waves, wherein wind waves are generated by immediate local winds, while swell waves are generated by distant weather systems, which in the recent case that has been highlighted in this article, these swell waves have been generated as far away as Madagascar. Now hopefully you have understood as to what are swell waves. And so with this we move on to the next article. Now we have taken the lead editorial from page 6. Now what this article talks about is the issue of poverty and inequality, and has been made in the reference to an earlier lead editorial of the Hindu newspaper of 4th of April, which was also covered in the DNS of 4th April 2018. So with regards to this article, what we'll do is understand as to what has been the focus and the arguments put forward by the author. Now what this article talks about is inequality and poverty. Now, according to the author, in India, there are instances in which a public policy focused on the reduction of inequality may not result in the reduction of poverty. So, according to the author, inequality can be reduced by taxing the rich, which is a form of leveling down. And moreover, according to the author, poverty can be reduced by raising the incomes of the poor people, which is a form of leveling up. Now, hopefully, up till here, you've understood that the reduction in inequality and the reduction in poverty are not causative of each other. Wherein, in India, there have been instances of public policy which are focused on the reduction of inequality, which do not result in the reduction of poverty. And the author has highlighted that inequality can be reduced by taxing the rich, which is a form of leveling down, while poverty can be reduced by raising the income of the poor, which is a form of leveling up. Now, according to the author, the focus on reduction of inequality and poverty through the equalization of capabilities, such as through the opportunities for livelihood for the poor, which would raise the income of the poor and thereby reduce the gap in inequality and also allow the people to move above the poverty line. Now, hopefully, up till here, you also understand that according to the author, the reduction of inequality and poverty can be made through the equalization of capabilities, wherein the poor are given opportunities for livelihood, which would provide them an income and thereby reduce the gap in inequality. And similarly, the income would provide them an opportunity to move beyond the poverty line. Now, hopefully, up till here, you've understood as to what has been the argument of the author with regards to inequality and poverty. Now, let us understand as to what has been the focus of the author with regards to the role of economic reforms with regard to poverty and inequality. Wherein, according to the author, the poverty has declined in India rapidly since the reforms of 1991. Wherein, according to the author, the economics reforms have mainly focused on trade, industry, and finance sector. And according to the author, these sectors are mainly located in the urban area. And so, according to the author, the economic reforms had little role in the reduction of rural poverty. And similarly, the economic reform, according to the author, had a low role in reducing urban poverty. And this is because there was a rise in rural demand, which led to a reduction in rural to urban migration, and therefore led to a reduction in rise of urban poor. Now, hopefully, up till here, you've also understood that according to the author, the economic reforms of 1991 were mainly focused on trade, industry, and financial sector, which were mainly located in urban areas, and because of which the economic reforms had a very low role, according to the author, in the reduction of rural poverty. Since the main sectors were located in urban areas, they were not able to form income generating opportunities in the rural areas. And similarly, according to the author, the economic reforms also had a low role in reduction of urban poverty, since it was the rise in rural demand which had occurred a decade after the economic reforms. And this rural demand was driven by the growth in the agricultural sector, which led to a reduction in rural to urban migration. And this effectively led to a reduction in the rise of urban poor. And therefore, according to the author, it was the rise in the agricultural sector that improved the income opportunities for the rural poor in the rural areas, and because of which there was a reduction in the migration of rural poor to the urban areas. And this reduction in the rise of the urban poor led to a reduction in urban poverty. So now hopefully up till here you have understood as to what has been the focus and the arguments put forward by the author with regards to inequality and poverty. And this article and the explanation in this section thereby becomes relevant for your UPSC mains examination. It would be placed in GS paper 3 in economic development in the subsection inclusive growth and issues arising from it, and it would also be placed in your GS paper 2 in social justice section and more specifically issues relating to poverty. And so now with this, we move on to the next article. Now we have taken this article from page 9. Now what this article talks about is the Unlawful Activities Prevention Act. Now let us understand about the Unlawful Activities Prevention Act and its relation to Article 22. Now under Article 22 provides a protection against arrest and detention in certain cases. And therefore, under Clause 1 of Article 22, no person who is arrested shall be detained in custody without being informed. However, according to Clause 3 of Article 22, this protection shall not be applied for an enemy alien or to any person who is arrested or detained under any law providing for preventive detention. So therefore, under Clause 7 of Article 22, it provides for the Parliament to make a law under which a person may be detained for a longer period for preventive detention. So therefore, it was within this respect that Parliament enacted the Unlawful Activities Prevention Act, and this law extends to whole of India, including Jammu and Kashmir. And the purpose for this act is that it provides for more effective prevention of certain unlawful activities of individuals and association. So hopefully you have understood that under Article 22 of the Constitution of India, which provides for protection against arrest and detention in certain cases, however there are exceptions to the protection provided under Article 22, wherein it shall not apply to any person who is an enemy alien and to any person who is arrested or detained under any law providing for preventive detention. And therefore, under Clause 7 of Article 22, Parliament by law prescribe for the circumstances under which a person may be detained, and it is under this provision that Parliament enacted the Unlawful Activities Prevention Act of 1967. And the purpose of this law is to provide effective prevention of certain unlawful activities of individuals and associations. So with regards to this section, what becomes important with regards to your upcoming prelims examination is the exemptions to Article 22. And so now with this, we move on to the next article. Now we have taken this article from the editorial page on page 6. Now what this article talks about is the Rohingya crisis. So let us first understand as to why this article is in the news. Now Myanmar has claimed that it has repatriated a Rohingya family. Now repatriation means the return of someone to their own country. So Myanmar has claimed that a Rohingya family has returned to Myanmar, which is their own country, after they have left as refugees to Bangladesh. However, Bangladesh and the United Nations have raised doubts about this claim, wherein Bangladesh has said that this Rohingya family has not traveled into its territory and therefore were not refugees in Bangladesh, and therefore the claim of repatriation by Myanmar does not exist. So, with regards to the claim by Myanmar that a Rohingya family has returned to Myanmar after being refugees in Bangladesh, has been opposed by Bangladesh and the United Nations, which have raised doubts about this claim, wherein Bangladesh claims that the Rohingya family has not travelled to Bangladesh and therefore were not refugees and probably were in Myanmar territory. So, therefore, there was no instance of repatriation by Myanmar. Now the Rohingya crisis has been in the news for a couple of years, and this news is in transition and should be seen within the regular coverage of the Rohingya crisis. So what was necessary to understand from this article is what is repatriation for a basic conceptual understanding, and should be seen in context to other terms such as non-refoulement, Kofi Annan Advisory Commission, which are regularly used in the context of the Rohingya crisis. Now, a question with regards to Rohingya has already been asked in the UPSC examination, and this question was asked in the prelims of 2016 with regards to the location of the Rohingya community. So, hopefully, up till here, you have understood as to why this article is in the news and have a conceptual understanding of repatriation and how it links with the Rohingya crisis. And now with this, we come to an end in the analysis of today's paper. Now we move on to the question for today.